Welcome back to the Texas Agriculture Law YouTube channel. I'm Tiffany Lashman. We're here today to run through some March ag law hot topics. We have reached the last week in the month, and so we're going to just run through some of the things that have been in the news over the last 30 days. I will give you a caveat. We are recording this on March the 21st. So if something happens crazy in the last week of the month, we'll catch that on our April hot topics list. So let's start with number one, another update to the Corporate Transparency Act. At the very beginning of March, FinCEN, which is an agency within the United States Department of the Treasury, announced it is not going to be enforcing the Corporate Transparency Act beneficial owning requirements. So for several months now, there has been almost weekly back and forth about, is the reporting requirement law in effect? Is it not? Is there an injunction? Is it lifted? Now we know that the law is in effect, but that FinCEN is not going to be enforcing it. There will be no penalties for failing to report. The Department of the Treasury has also announced that they are going to work on making a new rule that should actually be out any day now that is going to limit reporting to foreign persons and entities. So if you're a domestic person, if you've got a domestic entity, there's not going to be any reporting requirements for you under that new rule. So like I say, I know there's been a lot of back and forth. There's been a lot of confusion. At this point, the Corporate Transparency Act requirements are not being enforced, and soon there will be a law or a rule that says they will no longer be applicable to domestic entities or persons. Number two, there was a big announcement from USDA this month. Secretary Rollins announced that there's going to be a new emergency aid program for farmers. This is going to all come through what's called the Emergency Commodity Assistance Program, or ECAP. You know that USDA loves their acronyms. And so the ECAP program is going to disperse $10 billion of economic aid to row crop farmers that will be distributed. Additionally, USDA is also going to use ECAP to distribute the $20.8 billion in disaster aid that was announced earlier. So that both the economic aid, which is this new $10 billion announcement, and the disaster aid, which was a $20.8 billion announcement, both of those are going to be distributed through this ECAP program. They're really pushing. USDA has said they're going to push to get this up and running and get payments out the door. So I would touch base with your local USDA office to see when they're ready to start doing any signups that may be necessary. Number three, the EPA has made an announcement that they are going to, again, revise the rule for the definition of waters of the United States. If you've been around for a while, this is a topic that has been ongoing now for well over a decade. Talk about a pendulum switch. Every time we get a new administration over the last decade, we've gotten new definitions of waters of the United States. So keep an eye out for that. EPA is going to hold 6 listening sessions around the country to get input. They will then announce their rule. They'll go through the notice and comment rulemaking process. They'll publish that in the Federal Register. They'll take comments. And then, in all likelihood, there will be lawsuits challenging this rule once it becomes final. Number 4, this is a follow-up to a story we talked about last month and that we had a blog on our Texas Agriculture Law blog page. Sinagro, which is a fertilizer company, has released an independent study that they had done by an independent company and a professor at Purdue. And they did a study of the PFAS contamination in Johnson County. You might recall from last month that there's been lawsuits filed by a number of farmers and ranchers in Johnson County claiming that Sinagro fertilizer, it was a biosolid fertilizer, contaminated the land, the water, their animals with PFAS. Sinagro has now released this independent study. It came out in the last week or so, and the independent researchers found that their fertilizer, the Sinagro fertilizer, could not have caused the PFAS contamination on animals or fish on the neighboring properties. So like I say, that's just the next kind of step in the litigation, that's Synagro's perspective now, is that they were not the cause of that PFAS contamination. So that's something we'll certainly be watching as that litigation moves forward. Next up, this is something that happened back in February, but it just wasn't on my radar. And that is that a court in the lawsuit Environmental Working Group versus Tyson Foods has denied Tyson's motion to dismiss. So from a legal perspective, what that means is the lawsuit's going to be allowed to go forward. They're going to go through discovery. They'll do motions. Eventually, it could potentially go to trial. But the lawsuit will not be kicked out kind of at the early pleading stages. So that certainly is a win for the Environmental Working Group who brought this lawsuit against Tyson. You might remember reading about this. The lawsuit really relates to some claims that Tyson makes regards to their environmental sustainability. So one claim that Tyson makes is that they're working to become net zero by 2050. And then the other challenge claim relates to what Tyson has labeled as their climate smart beef. The plaintiffs in this case claim that those statements are fraudulent and misleading. And like I said, the court has allowed the case to go forward. Certainly doesn't mean anything about who will be eventually successful, just means that at the motion to dismiss stage, the court found that the plaintiffs had enough evidence to state a claim. And then number 6, we're going to have a bonus this month. I couldn't fit it into 5. The United States Court of Appeals for the 10th Circuit has issued a really interesting and important ruling for a number of Western states. And the issue in that case, we did an entire blog post on this over on our Texas Agriculture Law blog, and we'll link to that in the show notes below. But the issue in this case deals with land out west, particularly in Wyoming, that's checkerboarded. And so you've got a situation where you'll have a square or a section of land that's in private ownership, and the next one is government owned, and private and government. So it kind of makes like a checkerboard of the land ownership. The question came up several years ago, if there are elk hunters that are hunting on public lands, can they corner cross, right? So if we've got 2 squares that are publicly owned, can they cross over the corners to get from one publicly owned piece of property to another? The landowners of the opposite corners, right here we have private landowners, they said that corner crossing constituted trespass. And this week, the 10th Circuit disagreed with those landowners, sided with the hunters, and said that corner crossings are not trespass. So like I say, lots more information on that case in our Texas Agriculture Law blog. That's it for our March Ag Law Hot Topics. Come back in April. We'll have more information then.